As Chief Justice of India, it has been my very firm conviction that we need to take the process of justicing and the administration of law to the homes and hearts of people.
Thank you very much for those insightful words, Chief Justice. Of course, being a member of India's Supreme Court, a big part of your role is to adhere to very strict legal principles, which form the bedrock of the Indian Constitution. How then do you balance a strict adherence to these legal principles with the imperative to humanize the law?
Well, a large part of the work which judges do is to interpret the law. And the law uses phrases very often which are ambiguous, phrases of a very broad content and diversity in itself. And that is, I think, the essence of the task of judicial craftsmanship, to allow for an interpretation of the law which would facilitate achieving the purpose of the law and facilitate achieving the purpose in a manner which is consistent with constitutional principles. So if we are dealing with a case involving affirmative action and the law provides for affirmative action, the effort of the court would be to humanize the outcome of the case without doing injustice to the language of the law by using phrases or interpreting phrases which the law embodies in a manner which would further the ideals of the law, in a manner which is consistent with the Constitution. Because the task of a judge in a constitutional democracy like ours, the task of a judge is not just to promote adherence to the rule of law, but to promote the adherence to a rule of fair law, both in terms of its procedural implications and the substantive outcomes.
And of course, you mention one of your recommendations for humanizing the law, as you just mentioned, is courts making judgments focused on the effect of those judgments. Do you then believe that a commitment to humanizing the law necessarily entails an activist court?
Well, speaking for myself, I mean, that's possibly a matter of experience. I don't really believe in binaries of human existence. I look at the law and the function of the judge in more fluid terms. So when a judge is interpreting the law to give effect to constitutional values, or focusing on the effects of a particular interpretation as opposed to merely the purpose of the law, the judge is not really being an activist. When we call judges activists, it has a sort of a pejorative implication that the judge is trenching upon an area or domain which is reserved for the executive or the legislature. Now, as judges, we are deeply conversant with the fact and cognizant of the fact that there's so much that we can do, and so much which in a democracy governed by the rule of law and the separation of powers is meant to be done by the legislature, by our parliaments, by our state legislatures, and by the governments who are elected governments of the day. And we respect that distinction between what is assigned to the legislature, what is assigned to the government, the task of administration, and what is assigned to us, the task of adjudication. But having said that, therefore, I wouldn't really say that the work which we do is of judges who are activists. But I think it's a plain sense of duty, because when the Constitution established an independent judiciary governed by principles of judicial review, which we of course have imbibed from our common law tradition and which we have built upon, at the same time, I do believe that the work which you do is just a matter of plain duty and nothing more than that.
Of course, that's very interesting. You bring up the important aspect of the separation of powers and the roles of the legislature versus the judiciary. Of course, applying this to a very infamous recent ruling, the ruling on the Special Marriage Act last year, your justification for delegating the legislation of same-sex marriage to the legislature was that, in your own words, the judiciary cannot legislate. Do you believe that this principle is compatible with the judiciary's duty to humanize the law?
Well, of course, it is the duty of the judiciary to humanize the law, but equally when you humanize the law, you cannot disregard the law unless you strike down the law. In a country like India, which is governed by a constitutional principle of judicial review, the court has not merely the duty to interpret the law, but the authority in a given case to even strike down the law. Now, you call the judgment in the Special Marriage Act case infamous, but I'll just share with you what the real issue was. And I'm not here to defend the judgment, Because as a judge, I believe that when you deliver a judgment, it becomes the property of not just the nation, but global humanity. Therefore, it's for others to critique the judgment. But I'd just like to tell you this, that the Special Marriage Act was a law which was enacted by Parliament, and the purpose of the law was to allow for couples belonging to different religious faiths to enter into marriage. Now, the law uses the expression man and woman. So the law is very clear. It contemplates a marriage in a heterosexual relationship. It provides for a variety of other things, including succession, including things like which are the prohibited relationships which cannot enter into a marriage for men and women separately. Separate ages of marriage for men and separate ages of marriage for women. So what we felt was that nobody wanted the law to be challenged, because if the law was struck down, you'd be in a situation where there would be no governing principle allowing for couples of different faiths to get married, which the Special Marriage Act does. So here you have a law which specifically uses the words man and woman. Can the court then override the provisions of that law and read that as man and man or woman and woman? And we said we can't do it. Now, another aspect which I must emphasize is that the entire gamut or domain of marriage is governed by legislation in India across communities. Now, therefore, we felt that if you have to recognize same-sex marriages, this is something which has to be done by Parliament, which is entrusted with the duty of lawmaking. But I must also share with you that I was in a minority in that case on a certain specific aspect, because I believe that the court should recognize at least the right to form civil unions for same-sex couples until such time as Parliament stepped in and legislated on the subject. 3 of my colleagues didn't agree with us. They felt that even the recognition of same-sex unions was beyond the purview of the court. But having said this, and I'll leave the question with just this thought, that what happens in courts in modern democracies is not only to be looked at in terms of the substantive outcomes of a case. The court is involved in a continuous process of dialogue. A dialogue not only with the litigating parties, but a dialogue with wider civil society. And that's one of the reasons why we have now decided to live stream our important constitutional cases. Because as Chief Justice of India, it has been my very firm conviction that we need to take the process of justicing and the administration of law to the homes and hearts of people. People must understand that the smallest issues which come up before the courts attract the most serious of application of mind. And in this case, I do believe that between the date when we decriminalized homosexuality in Navteej Singh Johar and today, there's a wider societal acceptance of these relationships. And I do think, speaking for myself as a judge, that there is so much which has to be done by society itself and by other wings in a modern democracy. You cannot look to the courts to resolve every issue of dispute that may arise in society. It's important as judges that we draw the line and decide what legitimately belongs to our jurisdiction and what legitimately belongs to other wings of society, including civil society itself.
I just wanted to pick up on that point. Do you then believe that without the cooperation of the legislature and greater civil society, the law cannot be humanized?
Well, I do believe that, the legislature has performed a very valuable role in humanizing the law. You have a host of social welfare legislations, and that's not true only in India. It's true in South Africa. It was true in, say, the New Deal legislation, which came into the United States in the years of the Great Depression. So legislatures across jurisdictions, across civilizations and time have attempted to humanize the law. But having said that, there are obviously interstices which are left undefined by legislatures. Very often, legislatures look at the wider social good which the law has to follow. And in the pursuit of the wider social good, which legislatures legitimately follow, and we respect them for doing that, there is always the danger of individual cases leading to grave injustice. And I believe that is where the critical role of a judge comes in, to ensure that while you do not disregard the law, the letter of the law, you also craft your opinions and your remedies and your reliefs in a manner which would protect the ends of justice in a particular case. And there's a provision of the Indian Constitution which is very unique because it allows the court, the Supreme Court, to do complete justice to the facts of that particular case, and which we employ very, very regularly.
Thank you for that. I'd just like to expand the scope of our conversation to an international scale. I was curious as to how Indian courts take inspiration from international law and proceedings before international courts. So, for example, with the South African interim measures application against Israel before the International Courts of Justice. Do Indian courts look at such instances of intervention as positive or guard against overreaching their mandate under local laws?
Throughout our history over the last 75 years, we have extensively looked at international conventions, including in particular conventions to which India is a party. So you would find a very repeated reference to the Covenant on Civil and Political Rights, or Economic, Social and Cultural Rights. So we have never stopped short of looking at the emerging consensus in the international community while interpreting provisions of our own law. I'll give you just one example. The Convention on the Elimination of All Forms of Discrimination Against Women was one of the key components of the decision of the Indian Supreme Court when we dealt with the protection of women against sexual harassment in the workplace, which eventually led Parliament to enact a law following a judgment of our court. So you would find in a whole host of areas, we have relied on international treaties, conventions to which India is a party, and sometimes even those to which India is not a party. The other area where we have relied on comparative jurisprudence, including jurisprudence from the UK, is judicial precedent, which is not in that sense international law strictly speaking, but we are adopting principles of judicial interpretation followed by other jurisdictions, including the UK, Australia, South Africa,